Good afternoon, everyone. Thank you so much for coming to the presentation today. We're so excited to share with you all about estate planning, and we hope that you learn a lot. And we're also looking forward to any questions you may have. I'm Loishirl. Like Andy said, I practice in Maryland and DC. I live in Laurel, Maryland, and I work at McCabe, Weisberg, and Conway. I work mostly on real estate matters, but a lot of my work sometimes incorporates like probate and a little bit of trust, but mostly wills and probate. So, and I'll let Peyton introduce herself as well.
Sure, thanks. I'm Payton Smith. I'm an attorney here in Georgia. I live in the Atlanta area, but I work in Alpharetta. I work for a firm called Loishirl Law. We work in estate planning, real estate, and business formation. And it comes in handy because a lot of those things you wouldn't think they overlap, but they do. But we're really excited to talk to you guys mainly about estate planning today.
So, estate planning, what is it? So basically, estate planning is a plan that you come up with so that you can determine what happens to you and what happens to your belongings, both your personal possessions and your property in the event that you're no longer able to take care of them or no longer able to have a say so. Um, so a good probate plan or a good estate plan has a directive about who receives your assets. It also has a clear end of life or medical directive. It lists out the guardians for your children, or if you have any pets and you want to have a specific person take care of your pets or your children. It also ensures that your family is taken care of financially, and it reduces the taxes and probate costs that may be incurred by your estate if you have those planned in advance, so that more of your wealth goes to your loved ones and not the state. So if you have a good plan in place, this kind of protects your assets and you have more of a say so in what happens to your things and your property. So here are some helpful statistics, and I'm going to read the statistics. They kind of give some good perspective. And these statistics are from a 2025 estate planning survey from caring.com. 64% of Americans say that estate planning is important, which is an increase from the 2024 survey. We presented some stats at last year's presentation, so it increased a little bit. 32% of US adults actually have a will, which is around the same. Um, and you notice that even though a lot of adults think that having a will is important or having an estate plan is important, not as many actually have one in place. And I think that increasing the knowledge about what it is, how to create one, that increases people's likelihood to actually have one in place. So, among individuals that are 55 and older, only 46% of them have estate planning documents in place, which is a little decline from 2024. 17% of Americans 55 and older have the big three essentials: a will, a healthcare directive, and a durable power of attorney. The probate expenses still consume about 10% of an estate's value, and nearly 9 in 10 of Americans 55 and older say that their parents should be the one to start legacy conversations with their children. And this is really interesting because this is a topic that no one really wants to broach, but it's something that's inevitable that happens to all of us. So we do need to increase the knowledge and our exposure so that we can have those hard conversations, so that if something happens, no one is scrambling to decide, oh, what do we do? Instead, there's a plan in place and that plan can be executed. And then 41% of older adults are worried that they don't have someone to advocate for their best interest in the event that something happens to them. So, who needs an estate plan? Well, the short answer is everyone. But um, if you're thinking, oh, do I need an estate plan? Well, if any of these apply to you, then it would be a good idea to have an estate plan. If you want to avoid probate going through the courts, you may want to have an estate plan. And if you want to keep your financial information private, if you want to protect your assets from creditors or lawsuits, or in the event of a divorce, if you want to separate that financial information, you might want to have an estate plan in place. If you want to prevent family conflict, a lot of times, if there are big families and there's not a clear plan about what is going to happen, there can be some family discourse amongst parties, and this can end up bringing division between families. But if there's a clear plan in place and there's a clear directive, then the family has no choice but to honor those wishes. If you want to plan for incapacity, we never know what tomorrow holds. So if there's even a chance that you could become incapacitated, but you want to make sure that there's a plan in place that you're protected, you need an estate plan. And if you know what you want to happen to you in the event of a medical emergency, then you also need a estate plan. So, bottom line, again, in short, any adult who wants their voice heard in the event that their voice can no longer be physically heard needs an estate plan. So, an estate plan getting started can seem like a lot. Some people don't know where to start. So, we've compiled a list of where to get started, kind of what things to start thinking about before you begin creating your estate plan. So, the first thing you want to do is take inventory. These are all of your assets that you have. This is property you may own, personal possessions that may mean a lot to you, whether they're sentimental value or family heirlooms, anything that you have that you want a specific person to receive. Just think about anything that you would want to pass down to someone. The next thing is think about beneficiaries. You want to have a list of very specific people to like be the inheritors of your belongings. After you have listed the beneficiaries, now you want to create a will. And basically a will outlines your intentions. And later on in the presentation, we'll kind of differentiate between a will and a trust. But you want to choose decision makers. And this is really important because if you have a list and you select someone that's not as trustworthy or not able to carry out your wishes in the way that you wish, then it kind of defeats the purpose of having an estate plan. So you want to make sure that you choose someone that you really trust and that you know will be the one to carry out those things that you want. So also you may want to consider having a trust. So every estate plan doesn't have a trust, but a trust is a very valuable mechanism for um, transferring your wealth. And Peyton is like the trust expert, so I will let her speak on on like the trust and everything. Then you want an executor. So an executor of the will is a little different than the decision makers. So the executor is one person, and some people sometimes select more than one executor, but we, don't really encourage to like people to have more than one executor because that's when contentions can come along. So you want to have one person to really be the one to execute what you want to happen. You want to start thinking about planning for taxes, being aware of transfer taxes, of any kind of estate taxes that you may be obligated. Also, don't forget digital assets. A lot of people, sometimes something happens to them and they haven't shared their passwords or written them down or anything. So no one is able to get into any of their online accounts. Um, you also want to leave a guide for your loved ones so that they know. A lot of times people make a plan, but then they don't share it with anyone. So then their loved ones are still left kind of guessing what they want to happen. And lastly, you want to make sure you're reviewing these regularly because life happens. Sometimes we get married, sometimes we have kids, sometimes we graduate, sometimes we change houses. So there are a lot of different life events that happen, and we just want to make sure that our current estate plan is reflective of any changes that have occurred. So, what do I need for a will? And this is just a short recap of our last event. Um, So, just like the estate planning, you want to make sure that you have your assets, your real estate, any vehicles, any personal property. You want to also make sure to list bank accounts, stocks, bonds, life insurance policies, and it's also important to make sure that the beneficiaries listed in any policies match beneficiaries in your estate plan. So identify your beneficiaries. Oh, sorry. Um, Identify your beneficiaries, select an executor, and have it written in a secure place that upon your passing, the executor knows where to locate it and how to carry out those wishes. So at this point, I will turn it over to my wonderful colleague, Peyton.
Thank you so much. So now let's talk a little bit more about a trust. So as we talked about with a will is just a way for you to make sure that your voice is heard and that your assets are distributed to your loved ones as you intend. So I want you guys to think of a trust as the same thing. It's just another way to accomplish that goal. It's another document to make sure that your voice is heard and your assets are distributed according to what your wishes are. So with a trust, there are three main players involved. There is the grantor, that is the person that is creating this trust. That is the person who is putting their assets into this trust. And then you have the trustee. That is going to be the individual or the institution that is managing the assets that are in this trust. And then you have the beneficiary, which is the person who is receiving the benefits from this trust. Now, if I want to move on. So there are two main types of trust. There is a revocable trust and an irrevocable trust. So I'm going to be very honest with you guys. For estate planning, in my line of work every day, the main trust that we use is a revocable trust. So I'll talk about an irrevocable trust a little bit more, but in terms of estate planning, a revocable trust is going to be what you most often see. So what a revocable trust is, it is revocable. You are able to change it throughout your lifetime. So we talk about a revocable trust in the way is you're putting things on paper, you're not putting it in stone because you can change it later on. With a revocable trust, you still have those three key players of the grantor, the person creating the trust, the trustee, the one managing the trust, and the beneficiaries. But the main thing to remember here with a revocable trust is that you, the person creating this trust for estate planning purposes, you are going to have two roles. You are going to be the grantor, the one creating the trust and putting your assets in that trust. And you're also going to be the trustee during your lifetime. You're going to be the one managing these assets. And then you're going to select someone to be your successor trustee who's going to fill that trustee role and continue managing these assets and distribute them as you see fit once you have passed. So a main thing to remember about a revocable trust as well is that because you are in those two roles, you are the grantor and the trustee, you have direct access to the assets within that trust. So therefore, you're not getting any kind of asset protection or creditor protection with a revocable trust because you have direct access to the assets that you've put into that trust. But a great thing with a revocable trust that it does do is that it helps avoid the probate process. So probate, once you pass, your family members have to go through a process to verify your will, to verify your belongings and your beneficiaries before those distributions can be made. It's a court proceeding, it's public, so a lot of times people want to avoid that probate process altogether, and that is a great thing that a revocable trust can do for you. So in terms of an irrevocable trust, like I said, these aren't used as often in estate planning, but they still can be used for some great purposes, such as using it for asset protection. How you're able to do that is you put assets into an irrevocable trust. You're the grantor, you're putting the assets into that trust that you're creating. But the key difference is here, you're not the trustee of an irrevocable trust. You're not the one that is going to be managing the assets here. So you're releasing some control of those assets in order to get that protection from that irrevocable trust. So those are often used in very specific situations. And like I said, a revocable trust is going to be the main form of trust that people are discussing when they are talking about estate planning. Now, a trust can be used for many different things. Like I said, the main purpose of a revocable trust in estate planning is to avoid that public probate process and to speed up and simplify that asset distribution process. So that way your assets are in the hands of your loved ones a lot faster, and it's a more streamlined private process. Another thing that a trust can help you do is that it helps you maintain control of the assets and how they're used by your beneficiaries, even when you've passed and you're no longer here. So what I mean by that is a trust allows you to put certain stipulations, certain rules in place for the assets that you are leaving behind to loved ones. For example, if you're worried about your loved ones getting their inheritance in a lump sum all at once, you're able to have their inheritance be doled out in stages by your trustee. You're able to help them plan for the future. You're able to say, I want these assets held in trust for my grandchild. I want those assets to be used specifically for college, to attend, a great university or a great college such as LaGrange. But another thing that you're able to do with the trust is you're able to support charities and organizations that are meaningful to you, such as LaGrange as well. You're able to leave assets within a trust to be used for specific charitable purposes. Now, I just want to recap the main differences between a will and a trust. Like I said, they're both ways to make sure that your assets are distributed as you want them to be distributed once you have passed. They're just different ways and different processes of how you want that to happen. So like we talked about, the main difference between the two is that a trust is going to avoid that probate process. That allows things to remain private and stay out of public court record. And then also by not having to go through that probate process, a trust, it doesn't delay asset distribution. Asset distribution is delayed when you have a will because it has to go through that probate process. So one thing as well that is different between the two documents is that a will only becomes effective upon your passing. A trust can be effective during your lifetime. A great thing that a trust can do as well is help you plan for incapacity. If you become mentally incapacitated one day and you're unable to manage your own assets, the person that you've selected to be that successor trustee can go ahead and step in early and help you with maintaining those assets and making sure that you're taken care of as well. One thing to note, trusts are a little bit more expensive to create now. A will is oftentimes going to cost less than a trust, but those costs, balance out later on in terms of what you were spending in the probate process or paying an attorney to help with the probate fees later on. So it's really just balancing out the cost of creating a trust now or paying for a will later on, whichever you see as more fit. And then another great thing about a trust is because you are out of that probate process, a trust is more difficult for a disgruntled family member to come in and contest that document. It's a lot harder to contest a trust than it is a will. So another great thing to remember is with estate planning, we're planning, for when we pass to take care of our assets, but we're also making sure that we're taken care of during our lifetime as well. So there are three very important documents that almost every estate planning attorney is going to make sure you have in place as well, because they're that vital and that important. And so that first document is going to be a financial power of attorney. A financial power of attorney is a document where you are designating a person in your life to be your financial agent. They are going to be someone who can help you with finances and make financial decisions for you when you're unable to do so yourself. And this can be whether you are incapacitated and unable to take care of your finances, or it can just be that you're out of the country and you need a check signed. Within the financial power of attorney document, you can definitely make that distinction of when you want that power of attorney to come into play. Now, another very important document to have is an advance directive. I'm sure those of you, if you've been to the doctor recently, I'm sure they've asked when you got there, do you have an advance directive? Do you have a healthcare directive? So what that document is you are designating someone to be your healthcare voice when you're unable to speak for yourself in medical situations. The Georgia form also has questions on there where you can go ahead and direct certain care that you would like to happen, especially referring to end-of-life care when you're no longer able to communicate what you would like to happen at that point. You can go ahead and designate certain wishes that you have. And then another important healthcare form is a HIPAA release. So what that is, you're able to list certain people on that document to guarantee that they're able to have access to your medical records and healthcare information. So in case you're unable to tell the doctor, hey, it's okay, you can talk to them about my care, they're on that document and they're able to have that information. So now we have just come back to kind of our roadmap that we set up for you as kind of the end of our presentation, because it's a good summary. And so now really we're open to any questions that you guys may have about estate planning.
All right, so let me come back. A little bit of a lively chat going on. Did have a question, not necessarily about estate planning, but from Dr. John Torres to see if either one or both of you distinguished attorneys would be interested in talking to one of his political science classes.
Absolutely.
So I'll put y'all together in an email string after this. I did want to point out something while we wait to see if there are any other questions that come in. I'm really glad that y'all talked a little bit about health directives, because that is a very important thing that a lot of people don't necessarily think about. But another thing I think are the digital assets, because a lot of times you don't think, somebody needs my password for things. And you're always hearing stories now, particularly with Bitcoin coming in so hard that you've got a Bitcoin wallet and nobody knows the password to it, so nobody can access it. So if you're heavily invested in Bitcoin or even lightly invested in Bitcoin, make sure somebody has that. Here's a question. For retirement accounts, is it okay to be a beneficiary? Okay to be as a beneficiary, quote, the state of myself?
So with any kind of financial accounts, I will say by putting a beneficiary on your financial accounts, that helps avoid probate for that particular asset. So if I put Andy as the beneficiary of my retirement account, once
Sweet.
I pass, that asset wouldn't have to go through probate. It would be a direct payout to Andy because he's listed as the beneficiary. So my advice would be to put an actual person on as the beneficiary there, because if you're just putting the estate of, then that asset is going to have to go through probate. But by putting a real person on there, then the financial institution can do a direct payout to that person.
And just to add on to that, because one thing we run into whenever we're trying to determine who owns the property, if someone has listed a remainder person as the estate of, and we're doing any kind of litigation, then we have to go through the probate process to have a personal representative of that estate appointed. And then whoever that personal representative is, that is the person that gets to decide what happens. So like Payton was saying, to avoid that issue, I think it's better to appoint or to name a specific beneficiary as opposed to saying the estate of, unless you have a specific personal representative. But even then, I mean, the area gets a little gray.
Mm-hmm.
And we have another question here. Can your beneficiary be your executor?
Yes. Your beneficiary and your executor can be the same. We see that very often. We see that people list, they want their estate to go equally to their children, and they list, their son or daughter as their executor as well. So yes, very much so.
Now, we'll say, because this is one thing I've had personal experience with, I think I've shared it before, that I think a point that Loishirl brought up is select an executor, not 2, 3, 4, because that does and can create problems. And I'll say from personal experience, I've seen that. I've seen that happen. So
as much as you say, my kids will get along and it'll be fine.
Right.
Just make it easier and appoint one of them and have the other as a backup.
Yes.
Now, we'll say in full disclosure, my brother and I did get along great when we were co-executors, but in order to really move things forward, I had to drop off as an executor. Otherwise, we had to be at the same place at the same time always to
exactly. You have to
make any
sign everything
decisions.
together. It just makes it easier to have one.
Yeah. But I think also the point of reviewing. I think a lot of times you think to yourself, okay, good, this is done. But as you said, life changes, things change. You need to go back and review to make sure everything is up to date in the way you want it. So let me ask you one quick question. I'm waiting to see if another question comes in. Do you need to designate in your will or trust or what to do with your pets?
So you don't have to, but I highly recommend, because I mean, that's your family member. You want to make sure that someone is there and taking care of for them. A lot of times we see people actually want to designate a person to take their pet, and they even will say, you can use these assets to take care of that pet. Another thing is, even if you don't include that information, and this goes for everything really, if anything is not included in your will or your trust, but you just want your family members to know, hey, I would like this to happen when I pass, leaving notes, leaving letters with your will is a great way to just, communicate your goals without having to change your will every time you have something, such as, what if you get a dog 5 years from now and you're saying, hey, I just want to make sure that Buddy's taken care of. That's something that you can definitely leave in a note to your family and keep with your documents.
Great. Had another question. Will the PowerPoint presentation be shared for attendees after the session? We will share a recording of the session. If you'd like a copy of the PowerPoint presentation, I'm going to drop my email back into the chat, and just email me and I will make sure we send you out a copy of the presentation. So let me do that. Also, just as we get ready to close here, I don't see any more questions at the moment. But if you have, talking more to audience members now, if you have ideas for other sessions you'd like to see us offer regarding finance, plan giving, any other subject like that, please email me. Again, my email is in the chat. A lot of y'all here work on campus, so you know me already. ageeter@lagrange.edu, and just send me your suggestions, and we'll try to match those up with someone from our, oops, yes, just a minute, John. Match with someone from our LEAP program, or maybe even someone from our faculty or another expert. So John Torres has asked if he can just unmute for just a second. So, all right, John, go ahead. I can't unmute.
Oh, wait.
Matthew making unmute.
Hey, Payton and Loishirl, how are you doing?
Hey, Dr. Torres.
Hi, doing great.
It's great to hear from you. I hope I'll send you an email because I got your emails there. If you just, I get each of you to like maybe just say a few words to like one of our classes or something, if you're okay with that.
Of
Yeah,
course.
absolutely.
Awesome. I know you got to run, and my class starts in 7 minutes too.
It was nice to hear from you, I guess, not see
Yes,
you.
yes.
Oh, it doesn't let me do my camera. So.
And
But I'm still bald and wearing one of those hats. So there you go.
Well, thank you all for coming.
Dr. Torres brought up a great point. If you want to go to the slide with our email on there,
Yes.
if you guys have any other questions, feel free to reach out to us, and I'll be happy to answer questions. I'm sure Loishirl will as well.
Absolutely.
And ladies, a lot of kudos and thank yous in the chat. Well done. Thank you so much. Are you going to go back to that first page?
Oh, yes.
Sure, you're going to go back. Yeah, go back to first page. Just a second. If you'd like to get in touch with Loishirl or get in touch with Payton, there's our contact information there. I'll give you all just a second here to write that down if you're interested. And again, you will receive a copy of the presentation. If you'd like a copy of the actual PowerPoint, email me, and I'll be happy to send that out to you as well. So, all right.
Thank you
again
so much.
Yeah. Thank you again for joining us today.
Yeah, thank you for coming, and thank you for having us, Andy.
All right. We'll see y'all next time. All right. Take care. Bye-bye.